Hi everyone, thanks very much for coming along to our session today. My name is Chris Smith and I am, as we said, Assistant Director at the Education Team at the Fair Work Ombudsman here in Melbourne. What we're going to do is cover off on a number of things today. We are, the Fair Work Ombudsman, we are the federal government agency responsible for workplace entitlements, workplace rights. They're the sort of things we deal with, and things that we're going to go through today will include things such as notice required to be given to employers, and things like that. And we'll talk about flexible working arrangements as well. So key things, a lot of things that we get questions about as they come in through our Fair Work info line. We'll cover off on a few of those today. So, things we've got, as I flick through the notes, what we're going to cover off today. So we'll touch upon the basis of parenting entitlements, where they come from, the parenting entitlements. We'll look at planning to have or adopt a child. Whilst away from work on parental leave, we'll talk a little bit about that and how that works and what your entitlements are going to be there and what you can and can't do. We'll talk about negotiating your work, return to work, how that occurs, what you're required to do. So there are certain requirements as far as the Fair Work Act is concerned. We'll go through that as well. And also balancing your work and family. So we'll talk a little bit about flexibility arrangements that can be looked at for you as parents and discussing that with your employer and so forth. What we'll do is we'll start with the National Employment Standards. Any of you heard of the National Employment Standards? Winner, Emma's on the money. Okay, good stuff. It always helps to bring a colleague along to the session. Okay, parental leave eligibility. And the Fair Work Act has these things, as I said, the National Employment Standards, as well as anti-discrimination rules, which we're going to talk a little bit more about later. The National Employment Standards, as they stand, they provide employees entitlements such as parental leave for time off when a baby is born or an adopted child is placed with you. They also provide entitlements such as transfer to a safe job. There's also special maternity leave and pre-adoption leave. And how those entitlements actually link up and how they apply will depend on one's eligibility, and we'll talk about that now. One of the first things you need to check to see if you're eligible for parental leave. So eligibility is based on two things. Number one, firstly, you have to care for a baby or a newly adopted child. Pretty straightforward. Secondly, that you also have met the minimum service period working for your employer. Now, the period of service is 12 months. So again, no surprises there, pretty commonly known. Full-time and part-time employees are included, as well as casual employees who have worked on a regular basis for at least 12 months with their employer. So some people wonder, am I casual? Do I get that entitlement? There is an entitlement if it's regular and ongoing work with the employer. 12-month period has to be reached by the expected birth date or placement date, and any leave is taken is included in those 12 months. We'll talk a bit more about the parental leave arrangements a little bit later in our presentation today. So this is the beginning of the journey. Exciting months when you're planning to have or adopt a child. Now, when you do so, you can expect fair treatment from your employer, and there's a range of protections and entitlements in place that do support this, and we have arrangements in place under the Fair Work Act. The first of these relates to your safety whilst you're pregnant and working. As we've got up there, we've got the safe job protections. If there are hazards linked to your normal job, or if illness or risks arising from your pregnancy mean that you should not continue working in that position, but you're still fit for work. So we have this scenario that comes up from time to time. Then the employer must try to find alternate safe work for you. So it's a requirement in the Fair Work Act. You may need to provide the employer with medical certificates saying that you are fit for work, but unable to perform your usual duties. Now, situations where this might happen, one that comes up from time to time is, for example, flight attendants who are not going to fly right late in their pregnancy. That might be an issue there. So there might be an alternate role they might be able to take up. Or it might be a case of somebody who handles hazardous substances as part of their work. They may be pregnant, it might be an issue at the time. So there is arrangements. If a person works to an alternate safe job, then you keep the same pay and conditions as what you would ordinarily receive in your usual role. So it is only for a finite period. If, on the flip side, there is no safe job available, then you may take what's known as no safe job leave. Now, there is some eligibility criteria that need to be met, and you need to provide a doctor's certificate to your employer. If qualifying for no safe job leave, then you'll be paid at the base rate of pay for the hours that you ordinarily work, and your parental leave entitlements will be seen as unaffected on that. If you won't qualify for unpaid parental leave, then your no safe job for that period would be unpaid. So that's what we have there. Also, with that, any accrued sick leave can also be used if you're unable to attend work because you are sick or injured as well. So any accrued sick leave that you have in place. Generally, one of the questions we do get in through our Fair Work info line, we get questions about whether sick leave can be used for the purpose of having routine appointments with your obstetrician and so forth. The answer is no. You may have flexible arrangements, you may have some annual leave owing, or you might come up with a flexible arrangement where you commence work early on that day and then leave a little bit earlier. So it's something best to communicate with your employer, and hopefully that you'll be able to organise something reasonably amicable between the two parties. Oops. Special maternity leave, as we have up on the screen. Special maternity leave is another entitlement which can be accessed if you have a pregnancy-related illness. It can also be taken in the case of illness or emergencies during pregnancy, such as a loss of a child within 28 weeks of the due date. So that entitlement's there too. Length of period of a special maternity leave depends on the reason that you're actually taking that. You'll probably be required to provide a medical certificate for the employer for that period of leave as well. To access special maternity leave, you will be expected to qualify for unpaid parental leave at that due date. But special maternity leave taken does not reduce your entitlement to unpaid parental leave. Also got a bit of pre-adoption leave as well. Those adopting a child under the age of 16 years, if you'll be eligible for parental leave at the time of placement, you can take up to 2 days of unpaid pre-adoption leave to attend interviews or examinations that are required as part of that adoption process. If, however, you take another type of leave, such as paid annual leave, then your employer may require you to do so. Last one we have here, we've got the pregnancy discrimination protections. Last one is there is protection for discrimination whilst you are pregnant. So it's illegal for an employer to discriminate or take adverse action against an employee because they are pregnant or because they may become pregnant, such as when the employer assumes that you're of a certain age and you're going to become pregnant at some stage in the future. There are provisions in place to stop that arrangement. Examples of pregnancy discrimination could include employment status being changed from full-time to casual, perhaps having hours reduced, or it could be looking at being dismissed or demoted. Now, most new parents want, if they can manage it, to take a period of leave from work to enjoy the most recent addition to their family. Straight up. Need to know the entitlements as to what they are, and so what I'll do is I'll run through them with you now. So first up, we have unpaid parental leave. Most employees, including the casuals, who've worked for their employer on a regular basis, as I said earlier, for over 12 months, are entitled to take up to 12 months unpaid parental leave. And you can request an extension to this by an extra 12 months to a total of 24 months, but the employer can refuse that extension on a reasonable business grounds. So you can certainly, as an employee, you can request it, but an employer can knock it back, but it has to be based upon reasonable business grounds, just to let you know that. If you want to, both parents, including same-sex partners, can share the 24-month unpaid leave entitlement, but any parent who wants to use more than the 12 months of this will need to make a request for an extension to their employer. Parents can take 8 weeks, or up to 8 weeks, unpaid parental leave at the same time. This applies if both parents are employees, but of course it doesn't have to be in the same business. So both parents are employees. They have this new arrangement, what's known as concurrent leave. And this is a relatively recent change. Concurrent leave can be taken in separate blocks during the first 12 months of a parental leave period, as long as each block is at least 2 weeks, unless it's been agreed otherwise with the employer. Also, one of the questions we do get through the Fair Week info line, a bit contrary to common belief, if you become pregnant again during or shortly after a period of parental leave, you don't have to work for an additional 12 months in order to qualify for your next lot of parental leave. Okay, so we do get quite a few queries, people phoning up, inquiring whether they're entitled to that. You don't have to work a full 12 months after returning in order to go beyond that. What about paid leave? One that's of most interest to most people here today, I'm sure. The Australian Government Paid Parental Leave Scheme provides eligible employees with 18 weeks of pay at the national minimum wage, which is currently $622.10 per week. As of January this year, dads and partners can apply for 2 weeks paid at the national minimum wage, so that's $622. And there are conditions around eligibility and timeframes for this entitlement, so you need to check these. In order to do so, There's more information available about the government paid parental leave scheme and dad and partner pay. It's available from the Department of Human Services if you want to follow up on that. So it's not one that we take care of as part of the Fair Work Ombudsman, but we thought we'd just pop it into the slides to let you know about it today. Department of Human Services is where you need to go. Dads and partners also may like to request other paid leave like annual leave or long service leave following the birth or the adoption of their child. And some employers may provide paid parental leave which doesn't affect your entitlements to that government entitlement. So if your employer provides paid entitlements, that's great. That's a separate entitlement to what you have under the government arrangement. Now, giving of notice. We do also get a lot of questions about this coming through our Fair Work info line as well. Some employers feel a little bit uncertain about how to do this, how to deal with it with their employer. Pretty straightforward in most cases, but the thing that we stress most importantly is to ensure there is good communication with the employer. Make sure that both parties understand exactly what's going on. Good idea, as we have up there, good idea to sit down with the employer to discuss what's ahead as early as possible. Give them at least 10 weeks notice, 10 weeks written notice. So not just a, hey, how you going, 10 weeks. You have to have it in writing, and it's a requirement under the Fair Work Act in the National Employment Standards, so that's set out. You also, if you plan to leave so for example, if you plan to start your leave 6 weeks before your due date, you'll need to provide notice to your employer by the 24th week of your pregnancy. So give you an idea of timeframes there. It's also your responsibility, so once again, employees have a responsibility to confirm with their employer the dates in writing at least 4 weeks before the intended start date of leave as well, so that's also important. So once again, it must be in writing. There's certain notification there. So 10 weeks, employee must provide. Confirm those dates at least 4 weeks ahead. Employee provides again. Both of them are going to be in writing. Many women choose to start their leave 6 weeks before the child's due to be born, but of course, for each of you and people here today, that will be a personal decision. Your employer can direct you to start your parental leave from 6 weeks before that due date. So the employer has a right to direct. If you and your doctor, however, feel that you're able to continue working, you can discuss that possibility with your employer and provide confirmation from your doctor that it's okay for you to continue working further and closer to that date of expected date of delivery. Partners, for the partners, the guys and various partners here today who'll be using parental leave also have access to this and have to provide the same notice periods. So that's a requirement as well. We have some useful resources on our website, including a parental leave checklist. So I've got the checklist there. Parental leave checklist, templates and example letters and notices. So in terms of some of these conversations, and particularly in regards to writing, we actually have done the work for you. All you need to do is print it out, write your name, relevant details, dates, put it all in there. We've already done the hard work. So you can go to our website, fairwork.gov.au, print it out and provide that to your employer. So that will actually save a lot of the work. And it's all very well written. We've got a very talented team back at the office. With that, we'll move on. Some things you may want to think about whilst you're away with your baby. We have these things called Keep in Touch Days, relatively new arrangement. It enables employees to stay connected whilst they're away on parental leave, and there are part day options. And we'll talk a bit more about them a little bit later, but there is an ability to take up to 10 days where an employee can take time off, can come into the workplace and may want to keep in touch if need be. If some people couldn't think of anything worse than going into the office, but some people, or going into the workplace, some people choose to do so to keep up with things, and that's perfectly fine. There is an ability, and we'll talk about an example in a few short moments. Accruing and taking leave. Whilst you're on unpaid parental leave, you don't accrue any leave. So any annual leave you won't accrue, personal leave you won't accrue once again. You can reduce, extend or cancel leave. So you can request to extend your leave. Isn't it obviously 12 weeks? You can take less. 12 months. Get that one right. You can actually take the extra 12 months if you wish, if you change your mind. But you have to give your employer written notice at least 4 weeks before the end of the initial period. So that's a requirement there. Often a person will be filling your role, so you have to do the right thing by the employer. Obviously, open communication is very important to ensure that things work out well. Consultation. The employer has to consult with you if there is any significant changes to your job. So there's a certain requirement there as well under the Fair Work Act. And ending employment. So if you decide that you don't want to return to work after your period of leave, you've decided you don't want to go back, that's fine. Again, talk to your employer. You'll need to provide the correct notice of termination as required under the Fair Work Act, usually based upon your length of service, and will be set out in your award, your agreements, or your contract if you have one in place. On the flip side, if the employer wants to terminate your employment, that's fine. They can't terminate your employment because of family responsibilities, because you've taken parental leave. This would be a case of discrimination. So there are certain things, safeguards in place to stop that sort of arrangement from occurring. If, on the other side, it's termination for another reason, such as redundancy, then your employer needs to give you notice based upon your length of service, and pay any entitlements, including any redundancy pay that may be applicable to you. Keeping in touch day, just talked about it before. Scenario, Georgia goes back, there's a new workplace computer system that's been introduced in her workplace. Whiz-bang system, fantastic. She knows she's going to be working on it when she gets back from parental leave. She uses one keeping in touch day to train of everyone else. They have a training day. They have a consultant who comes in and helps her out. She comes in and learns how to use it. She organises to have one keeping in touch day a month over the remaining 6 months of her parental leave in order to practice and retain those new skills. So it's great for her. She gets a chance, she goes in, she gets paid for those days. There's an entitlement to be paid, and she gets to keep up with what's going on. As I said, she'll get her normal wage for the days she works, and her entitlement to unpaid leave is not affected, so she still gets her full entitlement up to the date that she specified prior to going on parental leave. So that's one of the more recent changes we've had, and a few people have decided to take up on that. But of course, if you don't want to have a keeping in touch day and you want to hang out with your child, that's perfectly fine too. No issue there. Now, on negotiating the return to work. When returning to work, there are certain entitlements set out under the National Employment Standards in the Fair Work Act. You have an entitlement to return to the same job that you had prior to when you went on leave, and also to be the same pay as well. If that job doesn't exist any longer, then your employer must offer you another job that's nearly in pay and status to that which was equivalent with your previous role. Return to work. As I said before, communication, very important. Touch the base with your employer, get in contact with them before you do return to the workplace. You are required, you've set out a document, you've already provided a document to them saying you'll be returning on a particular date. Make sure you return on that date. As I said, contact in advance is always good. Good idea to get in contact with your employer at least 4 weeks prior to your return to work. And that way the employer you can confirm dates, first day back, and get arrangements in place so as you can be ready to make a smooth transition back into the workplace. And then communicate clearly, as we talked about before. So seek support if required from other workmates. Give them a call, see what's going on. Find out if there's any matters, any gossip going around the workplace, anything of relevance. And also stay connected with your employer. So maintain that. So once again, about making a smooth transition back into the workplace. Just touching on quickly, going to go with flexible working arrangements and balancing work and family. When you go back to work, obviously there are arrangements you have in place. You have a right to request flexible working arrangements until your child will reach school age. You think outside the box and be a little bit creative about how you're going to do this. Things such as changing start and finishing times, you might want to vary that. It could also be part-time work might apply. That's often quite common. Job share arrangements, career breaks, leave without pay. Could do some work at home. Some workplaces allow that and have flexible arrangements where you can look at that. There is quite a number of things there too. Requests for flexible working arrangements have to be provided in writing to your employer. They outline the details of your proposed arrangement and also the reasons for you wanting to access that as well. Once again, we've got a friendly template, a useful template on our website, which will enable you to do that. So if you want to print that out, and when you're going back to work, you may want to look at that, you can certainly print out the template, provide that to the employer, and hopefully that will be of great assistance. With the employer, if you put that through, there's a requirement. They have to provide a response to you within 21 days. The only way they can refuse it is on reasonable business grounds. So that's the arrangement there. And once again, create an arrangement that is good for you and for the employer as well. Just balancing work and families. There are flexible family-friendly policies and facilities. Some people have caring arrangements, some people have sick rooms, some people have a number of different arrangements in their workplaces. Not all, but that does happen. Carers leave, up to 10 days paid per year, so to take care of children. I know I never took as much carers leave in my personal leave, carers leave in my entire career as I did after my child started going to creche. It was a whole new experience for me, and everything that she got, she shared with my wife and I, so it was great. It accrues from year to year, so carers, personal carers leave, sick leave, so it's all under the same banner under the National Employment Standards. It accumulates from year to year. and it's up to 2 days unpaid for those who are on casual basis, employed on a casual basis. And expect fair treatment for you as a parent. There is certain safeguards in place under the Fair Work Act. With that, that brings me to the end of the presentation. As I talked about before, those templates and a lot of the information that I've talked about today available via fairwork.gov.au, working parents. The Fair Work info line, we have the phone number there, 13 13 94, if you do have any queries and you want to talk specifically about that. Or I'm going to be around for a while, as is a talented group of advisors over at our stand, G68, about 2 lines over that way. If you want to come and have a chat to me or to the team, please come on over, talk about your individual specific questions. We're more than happy. We'll hang around as long as necessary, and we'll certainly love to help you all out. So thanks very much for coming along today.